Hey everybody, John Skiba here, and in this video I'm going to share with you a very vital update on how to draft an answer to a debt collection lawsuit. Whether you've been sued by a junk debt buyer like Portfolio Recovery Associates, Midland Funding, Cavalry, Unifund, all the other list of horribles out there, if you've been sued by one of those or by just a regular creditor like Bank of America, Citibank, Capital One, I'm going to show you in this video how you draft the initial answer to the lawsuit so you can avoid a default judgment, avoid wage garnishment, and avoid that bank levy. But if this is your first time here to my YouTube channel, go ahead and click subscribe. That way you'll be notified each and every week when I put out a new video that'll help you deal with your serious debt problem. All right, let's talk about drafting the answer to a debt collection lawsuit. You know, earlier this week in my law practice, I was talking to someone who had called in trying to get some advice on what to do. And they said something that's very true and I think very relatable to anybody that's been in the situation of having had one of your creditors sue you. He said, you know, the process server came by, dropped off the complaint and the summons, and he said, I just panicked. You know, your mind goes to the worst place. You start thinking about you're going to jail. You start thinking about that they're going to take everything you have or garnish your wages and embarrass you at work, all that kind of stuff. And I know how that is, because if you're not familiar with what the process is, you start to get really nervous about what's going to happen, what they're going to be able to do to you, what they're going to be able to take from you. And the easiest way to avoid that early on is by filing a response to the debt collection lawsuit. So that's what I want to talk about and really show you how to do that in this video, is how to draft the answer to a debt collection lawsuit or complaint. Now, I should say I'm recording this. This is an update. I've done a video like this before on my YouTube channel. This is a 2021 update. I can tell you I have seen a significant uptick in the number of debt collection lawsuits that have been filed and that people are dealing with. The debt collectors are aware that there's more money circulating around. And you may be saying, you know, what are you talking about? We're in a pandemic. Things have been really tough for the last year. But there have been the 3 stimulus checks now. And those 3 stimulus checks, a lot of families are having a lot of actually extra income. Not only that, people who've even lost their jobs, unemployment is significantly higher than it has been in the past. So the debt collectors know that people have cash. They know that they're able to settle these things out or pay them, or worst case scenario, they're going to be able to garnish them. So we were seeing a huge increase in the number of overall debt collection lawsuits. So if you get served with one of these, you're likely going to get a document. It's going to be called like a petition or a complaint. It's usually accompanied with a summons. Most jurisdictions require that you file a written response to that, often called an answer, sometimes called a response, to the complaint or the petition, stating whether you admit or deny the allegations in the complaint. And usually there is a specific time period you have to file that response. For instance, in Arizona, it's 20 days from the day you receive it, you have to file your written response. If you don't, you're going to receive a default. They're going to default you. You're going to get a default judgment. They're going to give them everything that they're asking for. So that's why it's so vital to take this first step, not only if you have defenses that you want to assert, but it also gives you some more time to try to negotiate a settlement without already having a judgment entered against you. Okay, I'm going to show you here on the screen a typical video or a typical complaint from Portfolio Recovery Associates. Portfolio Recovery is probably one of the biggest debt buyers in the nation. They file hundreds of thousands of lawsuits a year. And so this is a generic one out of one of the local justice courts here in Arizona. Now I want to walk you through what each of the parts of the complaint are so that you understand really what it is you have to respond to. Now, I should say this, all complaints are not going to look exactly like this. They're going to look something like this, though. They may be a little more complex, they may be a little more simple, but I'll walk you through exactly what it is and kind of what you need to respond to. Okay, in the upper left-hand corner, this is where the attorneys for the plaintiff, whether it's a debt buyer, whether it's the original creditor, this is where the attorneys are who are representing the plaintiff in that action. Now, it's important to know, a lot of people think that the attorneys are the ones who actually own the debt or they're alleging ownership. They're usually just hired guns. They're just like any other attorney. The plaintiff is their client who's hired them to pursue this claim. So the reason why this is important is because when you draft an answer, it's usually on you to send a response, a copy of your answer over to the opposing counsel. Most courts do not do that for you. You have to file your answer, but then you're going to have to mail a copy over to their attorneys. So that's where you get their contact information. Like jurisdictions like Arizona require even email addresses now. You can email copies of it. that kind of thing. Then in the middle, this is the jurisdiction. This is the actual court that's handling your case. And it's important so you know where to actually file the answer. And then below that is what we call the caption. On the left-hand side is the plaintiff, Portfolio Recovery Associates, versus, and your name is going to be listed here as the defendant or debtor. They're going to list your name there. On the right-hand side of that, you'll see there's a place for a case number. And then usually it'll say complaint. And the reason why the case number is important, because if you're contacting the court or when you file your answer, obviously you need to put the case number on it so they apply it to the correct area. Okay, let's go down a little bit further. This is the body of the complaint. Now this complaint, fairly standard, fairly simple. It's 3 pages long, and there are 12 numbered paragraphs. Now you need to go through each of these numbered paragraphs and state whether you admit the allegation in that paragraph, whether you deny the allegation in that paragraph, or whether you just lack sufficient information right now to either admit or deny the allegation in the complaint. And now the thing you've got to realize as you go through this, you've got to be truthful with what you submit to the court. But if the information or the allegation that they're providing is not clear, or if it's open to different interpretations, then you can say you either deny it or you lack sufficient information. I can tell you, for example, often in lawsuits like this, the dollar amount that's being sought is different than what you may remember being on the original creditor. Maybe the credit line was $500, but they're suing you for $1,500. If you don't know how it is that they calculated that, I think it's fine, in my opinion, it's fine to say that you lack sufficient information as to how they calculated that, and so you're going to deny it at this point. And this is particularly true with debt buyer cases. This is a case where the creditor has charged it off, sold it to a junk debt buyer like Portfolio Recovery Associates. They will always have an allegation in there that the account was transferred to them. Very rarely do they provide any evidence at this stage. It's just an assertion. Unless you know or have independent knowledge that that actually happened, it's okay to say that you lack sufficient information and therefore you deny it or you deny it. And so you just need to go through each of those numbered paragraphs and state whether you admit, deny, or lack sufficient information. Let me tell you what you don't need to do. This is the number one mistake I see people make when they draft their answer. Often when people file their own answers and then I look at them afterwards, they usually go into huge stories of why they fell behind to the original creditor, why they missed their payments, maybe they even talk about settlement discussions they've had. Not only do you not need to do that, it could actually harm your case at that point. Really all the court wants to know is, on the one hand, we have the complaint that's been filed by the creditor, and then they want to know, what's your response to that? They want to know, is there a dispute? Do the parties have a disagreement about what it is that's being alleged by the plaintiff? All those other things are relevant and they'll be dealt with later on in the lawsuit, but with the answer, it's really important just to remain laser focused on what those allegations are and respond to those directly. Once you have completed the answer, then you're required to sign it, take the original to the court, give it to the clerk of the court so they can file stamp it. I always recommend bringing 2 photocopies of the completed signed answer so that the clerk can stamp both of those. You're then required to send one to the opposing attorney and then keep one for your own records that's time-stamped so you can prove that you actually filed this with the court. So that's really all it needs to be. It can be fairly simple. There are some other complexities in affirmative defenses and things like that. I'm not going to go into that for this particular thing. The main thing you want to do, though, is get an answer on file. Don't let that date go by. In most states, there's no grace period. If you miss it, you're done. And you're going to end up having not only the amount that they're seeking in the complaint, they're probably going to throw a couple grand in attorney's fees, maybe some interest, some court costs, and all of a sudden this, a $2,500 lawsuit turns into a $6,000 judgment. So making sure that you know what the relevant timeline is that you have to respond. You can often look in the summons and it will tell you. And then making sure that you take the time to draft the answer and get it submitted to the court and mail a copy to the opposing party. Again, that'll put you on the path, whether to litigate it and assert your defenses, or just giving you some additional time to possibly settle the claim so that you don't end up with some type of default judgment against you. So I hope that helps. I'm sorry if you're dealing with kind of this big surge of current debt collection lawsuits, but it's important if you know what steps to take, then those nightmares and those worst case scenarios you start running through in your mind, you realize that usually these things are very manageable and you can get it dealt with and move on. Appreciate you watching. Again, if you haven't subscribed, please go ahead and subscribe to my channel. Appreciate you watching today.